This is a termination case.
I'm sorry, Your Honor, I didn't think I needed an attorney, and so I'm not up on, it's a request to have a 30-day termination and have my home back.
From the very first words, Judge Simpson's tone signals this isn't a simple landlord-tenant dispute. It's about control, confusion, and a legal ticking clock. What starts as just a 30-day termination quickly exposes a tangled mess of verbal deals, missing leases, and emotional fallout. The property owner thought a friendly verbal understanding would be enough, but in court, friendly doesn't hold legal weight. Viewers, remember, verbal agreements in housing cases are legal quicksand. The judge's calm patience hides growing concern as both sides blur personal drama with legal procedure. Already, the tenant claims confusion, emotional distress, and inconsistent messages about staying or leaving. This is the classic storm. One side insists on generosity, the other feels trapped. Keep watching as Judge Simpson slowly untangles whether kindness became chaos, and whose version of events the law will actually recognize.
Right, but
So I'm not up on the lingo that an attorney would have for you. And I submitted some paperwork in my statement about what's been happening.
okay. So let me ask a few questions. Is there a lease?
No, sir.
There's no lease. Okay.
There's no lease. It was a verbal agreement. However, there was an ad that I included that they were aware of, and I gave them a lease, but it was never signed. And so we just went on a verbal.
Okay.
Between month to month, and they were given notice back in December that I wanted them to leave. It was initially supposed to be temporary anyhow.
All right.
Because Sarah was pregnant.
I got it. So
going to be homeless, and I knew I had a room for rent.
right, I understand that, but and has rent been paid?
Not for since December.
Okay.
And honestly, I told them not to pay rent and to just use that money towards their first and last months and to be able to get another place since they see.
I got you. So
I've been paying for everything, including utilities and covering all expenses except for their.
okay, I understand that. All right. What do you have to say about this?
The tenant's statement flips the tone fast. Suddenly, we're not talking rent, but accusations of assault, invasion of privacy, and manipulation. When a landlord uses their own key to enter without consent, it's not just bad etiquette, it can legally amount to harassment. The tension here isn't just personal, it's about power imbalance. The tenant paints a picture of fear and instability, while the judge listens like a surgeon separating emotion from evidence. For you watching, who's more believable so far? The emotional tenant describing chaos or the landlord describing compassion? These contradictions are why housing disputes often implode. A verbal understanding becomes a battlefield when no paper trail exists. The real question isn't who's right emotionally, but who followed procedure.
So, Your Honor, when we moved in, actually, we were gardening for her. So, what she said, I didn't know she was renting a room. I had discussed with her when we were working for her. I've worked for Miss King since me and my husband worked for her on and off since June of last year. But when I had my son in December and I was in the hospital, she started having issues with my partner, and she never once stated she wanted me out. She kept going back and forth. She has 1 minute said she wanted me to go, the next minute said she didn't. 1 minute she wanted me to go, next minute she didn't. This woman has used her key to come in and out. She has assaulted me. She has thrown my belongings. She is really, honestly, to be honest with you, I've never gone through such a traumatic situation with somebody I didn't know, to be honest with you. Because I was working for Miss King, it's been a little difficult moving. Trying to find this whole month, I've literally been trying to get out. I don't actually want to be near her.
Let me stop you. Let me ask you this, because there are certain things that have to occur. Your answer that you filed indicates, well, for asking you, what day did you give the notice to the tenants that they had 30-day notice?
Well, Your Honor, if you can see, again, I had some paperwork. The fourth page shows my, on December 11th, I messaged both of them.
Well, that's not my question. My question is, in order to invoke the jurisdiction of the court to handle this, I have to have a valid notice.
Okay, well,
And
so I formally filed notice in March after Aaron begged me not to because he said it would be-
okay. I don't care what Aaron said. I don't care what anybody said. I'm asking you a specific question.
So emailing them both and giving them verbal notice that they.
Ma'am. Listen very closely to me.
Okay.
There's a document that you have to file called a notice to quit.
Here's the first major turning point. Judge Simpson draws a hard line between emotion and statutory law. Notice to quit is not a suggestion. It's the key that unlocks the court's authority. Without it, the entire case collapses. The landlord admits she emailed and verbally notified them. Legally worthless gestures in this context. This is where the judge's experience shows. He's not being cold, he's guarding jurisdiction. Without the right paperwork, even a righteous claim can't proceed. Think about it. How many people lose cases not because they're wrong, but because they skip procedure? The judge's message is clear. Courts run on documents, not intentions.
And the one that I have, or notice to quit to recover possession of property, the one that I have in the file indicates that you served it on them, that you delivered it personally to them on March 1st of 2024. Is that true?
Yeah, that was after asking them to leave. Yes, I did that then. And Sarah has never worked for me, has never been employed with me.
Okay, I really don't.
Okay.
I mean, I don't mean to be crass, but I don't care. I'm asking a very specific question.
Okay, that was the only formal filing I did, yes, in March.
The notice to quit to recover possession of the premises indicates here that you served that to them on March 1st.
Correct.
You're indicating that you didn't get it until March 18th.
Yes, me personally. She and I discussed me staying, and on the 18th, when she assaulted me, that's when she told me and gave me this paper to leave. I noticed to quit.
Is that correct, ma'am?
No, it is not correct.
So you delivered it to her on March 1st?
Yes, and her husband.
Okay.
They were both aware of it. In fact, the
Well,
police-
whether or not they're aware of it or not,
Mhm.
I'm asking about the notice.
Yes, they were both given notice on that day. Yeah.
All right. So at the top, on the copy I have,
Mhm.
there's a date under paragraph 2 that says you must move by, and it's scratched out, and then a new date is put on there. When was that new date put on there?
It was put on when it was served to them and given to them because we had talked about it several times prior, and I had not given it to them. I gave it to them on the 1st. And that was written then.
Okay. Rent, when it is paid, is monthly. Is that correct?
Weekly, $180 a week.
This exchange reveals the heart of the confusion. Was this a weekly or monthly tenancy? The difference decides the entire legal outcome. The landlord says it was week to week. The tenant insists it was month to month. The judge pushes both until their own words betray them. When the landlord admits the payment schedule existed only because of how the worker got paid, the judge spots the truth. Monthly tenancy, not weekly. This matters. A month-to-month lease demands a full 30-day written notice, not a quick verbal heads up. The landlord's flexibility now looks like negligence. Have you ever done a favor that legally backfired? That's what's happening here. Judge Simpson knows intent doesn't change the statute.
Do you agree with that, ma'am?
I was trying to help them and I let them tell me what would work for them. And that was what Aaron suggested.
Okay, so let me try this.
Paying weekly, which has not happened since December. And that's because the police were out.
Okay, you guys let me know when you're done, and then I'll ask my question.
Okay, so you don't want me to say.
Was the rent supposed to be paid monthly, but you allowed her to pay it weekly? Or was the rental agreement weekly?
My normal thing would have been monthly, but they asked to pay it weekly. And I let them determine both their rent amount and how they wanted to do it because it was supposed to be temporary. They were being evicted and homeless. And so I just let them have the room and said, what would work? What can you afford until, you find another place?
Okay. Let me just try it again. Were you renting this out weekly to them or were you renting it out monthly to them?
I agreed to them weekly.
So it was
because that's what they asked for.
So it was a weekly rental.
Yes.
And you would agree with that?
To be honest with you, I don't know. Miss King is very confusing, and I never had a conversation with her. My partner did. She never spoke to me. I was under the impression that it was monthly. The reason why we were paying weekly was because she was having him work for her and taking some off for the work that he did during the week for her. So that's why we paid weekly, because she would take off what amount he did for her. What amount of work he did for her. I'm sorry. It was confusing.
Is that true, ma'am?
Most of I asked them, most of the money went back to pay for, the reason they were there originally was because I needed someone to do my lawn.
Okay.
And so the rent would go back to Aaron to pay for him doing the lawn and some lawn care. Sarah was never received any money, but most of the rent went back. And that's what I use that rent for, is to pay for my yard because I'm ill and I can no longer do it myself. So he would pay me and then I would use the money to pay him for any work he did. And that stopped in December.
So hold it. And you would pay him weekly?
Yes.
By now, the courtroom's energy shifts from storytelling to fact dissection. The judge is isolating one truth. Despite the weekly payments, this was still a month-to-month tenancy. Every time the landlord insists, "I just tried to help," the judge hears, "I didn't formalize anything." In law, goodwill can't override written structure. For viewers learning from this, the law rewards documentation, not intention. The minute rent terms blur into work exchange, liability skyrockets. You can't pay rent with favors unless it's on paper. Watch Judge Simpson's restraint. No emotion, just surgical questioning. His calm tone hides an unspoken warning. You can't improvise a lease and expect protection.
But the tenancy, okay, I'm going to tell you what I'm hearing. What I'm hearing is that it really was a monthly tenancy, but that the reason you were getting the monies weekly is because that's how you paid him. And then you would deduct out, he would do work. You would be paying him for that work weekly. And then keeping whatever portion, and that would go to rent.
Well, Your Honor, this is the first time I've ever done that, but that was what he asked me to do. And so.
Okay. Doesn't really matter if it's the first time, 100th time. I'm just trying to figure out what this tenancy was. So again, let me explain what I'm hearing. What I'm hearing is Aaron worked for you. There was an agreed upon, whatever it was, amount of rent, whatever that was, that would have, had he worked someplace else, been paid to you monthly, right? But it wasn't paid monthly only because he worked for you. You would pay him for that work that was done. The rest you would retain for rent. Is that, am I correct? Because that's what I'm hearing.
Yeah, I don't, I don't know what to tell you. I just did what they asked me to do. I was trying to help. And so, yeah, he would pay me. He asked to pay weekly, not because of me, but because that's what worked for him. He got paid each week. And I think it was a drug addiction problem and he wanted to keep things pretty tight. So he gave me the money, and then the next week I would use that money to pay him for any work he did the following week. And we had a verbal agreement that it was month to month, and that either one of us.
Okay, then I'm done. I'm done. Because, and well, everybody didn't want to answer my question.
Judge Simpson finally loses patience. His "I'm done" isn't anger. It's exhaustion with confusion. The courtroom descended into overlapping stories, side arguments, and emotional detours. This is where strong courtroom management shines. He cuts through the chaos to identify the single deciding factor, the tenancy period. Once he confirms it's month to month, the case narrows instantly. Legal insight: judges don't care about who's nice. They care about jurisdiction and notice compliance. Emotional noise fades, facts decide. Who do you think caused more damage here? The landlord for being informal or the tenant for escalating the conflict? Comment your view. The debate's real in every eviction courtroom.
I'm trying to figure out what the length of the tenancy is. There's a difference as to what has to happen if it's a week-to-week tenancy or whether a month-to-month. When you first got here, ma'am, you told me it was a month-to-month, which typically most rental situations are. But then there's this payment weekly.
Yeah.
But why does this weekly payment occur? Is it because they're renting weekly? No, they're renting monthly. The payment weekly only happens because that's how he's getting paid by you. And then you can pay him and then retain whatever there was for the rent. So really they were paying on their tenancy was for a month. It just got paid in these increments because of the work that was happening. Okay. So now I've taken this long circuitous route to try to get to my answer. It's a month to month. Do you have in front of you, ma'am, a copy of the notice to quit that I'm referencing that you sent to them?
I don't know that I do. So can I ask you a question, Your Honor? So you're saying on a month to month that it doesn't matter that you have verbally asked people to leave and given them a verbal and written notice via email, and also that they've agreed to be out by the end of January, that none of that.
Ma'am, I don't know why you're asking me that, and I'm not going to answer that. I don't know that.
Well,
I
I
ha-
the emails. Okay. All right. I understand I needed an attorney today.
Well, you're going to need an attorney another day, because do you have a copy of the notice to quit that you sent them?
Here, Judge Simpson delivers a subtle but brutal reality check. The landlord's "I didn't think I needed an attorney" echoes through countless small claims cases. She walks into a legal arena without a playbook and pays for it. Courts don't guide you, they enforce law. The judge even pauses to remind her that self-representation isn't immunity from mistakes. This is a teachable moment. Emotional intelligence doesn't replace procedural precision. For every viewer thinking, "I'll just explain myself," remember this scene. The judge's professionalism shields her from deeper embarrassment. But the message is clear: bring counsel or bring consequences.
I don't think I do.
All right. Let me tell you what the notice to quit that I have says. Notice to quit basically says in its relevant parts is that you've asked them under paragraph 2, there, and again, the date, the original date is scratched out. And written in there is March 30th, 2024. What?
Correct. That sounds correct.
Why are you looking at me?
Mine says, same paragraph, paragraph 2. This is the first paper I got. You must move by 3/8/2024, and she scratched off the date prior to that. So I don't,
What are you talking about?
this is the first paper she ever gave me, the notice to quit. Oh, maybe this is the 30-day notice? I don't know what.
Well, let me,
I have no idea.
did you give this to her? Show that to the plaintiff.
Well, it's my writing. Yes, I probably do give that.
And that says 3/8. So why does the one I have for the court say 3/4?
I don't know, except that I didn't file with the court. Aaron begged me not to file anything with the court because he said it would send him to jail.
Okay, I don't know how that happens, but it doesn't really matter. You have to, in order for the court to hear the matter, there has to be a valid notice to quit. Otherwise, because I'm a statutory court, I don't get what's called subject matter jurisdiction to even hear the case. So there are two problems here. One, which was the one I was getting to when I read off, when I was reading the dates, and why I was asking what the rental period was. It sounds to me, and you said it, that this is a month to month, which means you have to give them a month's notice.
This is the climax, the decisive legal interpretation. Judge Simpson confirms, even if everything else were perfect, the landlord's notice was insufficient. Giving only 29 days invalidates jurisdiction entirely. That single-day difference collapses the entire eviction attempt. One wrong date equals case dismissed. This is textbook procedural fatality. The judge's reasoning is cold, methodical, and unassailable. He's not siding emotionally. He's following statutory timing rules. The courtroom silence here says everything. Law beats logic when logic isn't documented. For anyone watching, this is the ultimate reminder. Eviction law isn't flexible. It's mechanical. Miss the timing, lose the case.
The notice that I have in the file is given to them on the 1st, according to you, is given to them on March 1st, telling them that they have to leave by March 30th. Even if I were being generous under the computation of time that's used under the Michigan court rules, that would be 29 days, which means you haven't given them a rental period to move if it's a month to month. So I don't believe that the court has obtained subject matter jurisdiction. I am also now concerned, as Ms. Goebbels then gives me a copy of the notice that she received, that it has a different date than the one that the court has. Even if I were to take that date as true, that gives 1 week.
Judge Simpson now dissects inconsistencies between the landlord's version and the tenant's document. 2 notices with 2 different dates. Instant credibility crisis. The legal issue transforms into a credibility showdown. For every landlord watching, duplicate or conflicting documents are poison in housing court. The judge can't trust either side, so he defaults to the law's baseline. No valid notice, no case. The courtroom tone turns resigned. Even the landlord realizes this fight is lost not on fairness, but on formality. This is how procedure silently overrules passion.
Actually, less than 1 week, but it gives 1 week for them to move out. Everybody, at least at this point, and I'll make the finding that this is a month-to-month tenancy. That's an insufficient notice in terms of the one that you gave her.
Wouldn't that be at the beginning of April
What would be at the beginning of April?
for them to move out, given a notice on March 1st?
I don't know what you're talking about.
Okay, well, it's clear that I needed an attorney,
Yes, you do.
and I couldn't afford.
And so we can stop this now because I can't do anything legally. The only thing I can do is I can dismiss this case because this court does not have subject matter jurisdiction to decide it. Case dismissed.
Thank you, Your Honor. Have a good day.
Case closed. Judge Simpson dismisses the action for lack of subject matter jurisdiction. Translation: the court legally cannot rule because the landlord never provided a proper 30-day written notice. No matter the emotional chaos, compassion, or conflict, law stands above it all. Key takeaways: verbal agreements invite disaster. Helping tenants informally can erase legal footing. Notice timing decides whether a case even exists. Emotional storytelling won't fix procedural flaws. Judge Simpson's calm authority reminds everyone that empathy without evidence has no courtroom weight. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.
Okay, this is the turning point. Once the body cam comes in, the narrative shifts from arguments to evidence, and evidence doesn't lie. Pay close attention to how the judge reacts and how the defendant responds to the video being played.